Good morning and welcome to this public meeting of the United States Consumer Product Safety Commission. We have one item on our agenda this morning, and that is a decisional meeting on the proposed rule, safety standard addressing the blade contact injuries on table saws. We have 4 members of our staff here this morning in case there are any questions from the commissioners in our opening round. We have Dr. Joel Reck, Associate Executive Director for Engineering Sciences, Ms. Kathleen Strelka, Associate Executive Director, Epidemiology, Ms. Caroline Paul, Mechanical Engineer from the Office of Hazard Identification and Reduction, and Ms. Hyun Kim from the Office of General Counsel. Thank you all very much for being here today, for the briefing you provided us a few weeks back, and for all of your work on this package. We're going to begin this morning with rounds of 10 questions per commissioner, depending on whether they have them or not, and then we'll move and turn towards the consideration of the proposed rule. I will begin with my questions. So I am wondering whether any of the staff, I'll address you 4, but if you can direct me anywhere else, have spoken to Dr. Gass and asked him to provide us with a list of his patents.
We have not.
Okay. So, and then we discussed this in the briefing. We have no idea the scope of his patents. We just know he has many of them out there.
That's correct.
Okay. Thank you. That's the only question I have for now. Commissioner Adler?
Thank you very much, Madam Chairman. I have no questions. I have just a very brief opening statement. First of all, I want to thank the staff for years of tremendous effort and a superb job done. And I want to thank you, and I think consumers across the land would want to thank you for the work that you've done. So I want to start by repeating a point I made at our briefing a month ago. In the 14 years since Dr. Gass filed his petition asking that CPSC adopt a performance standard requiring AIM technology, we've seen a grisly and ongoing accumulation of human tragedy resulting from table saw accidents. By my count, roughly 770,000 injuries and 56,000 amputations at an annual cost of billions of dollars. In fact, since our briefing about 4 weeks ago, if the statistics hold on average, we've probably seen 375 consumers who've suffered amputations and an equal number who've suffered fractures from table saws. I realize that as commissioners, we must dispassionately and thoughtfully assess the merits of mandating a rule on table saws, and I'm certainly prepared to do that. But I also want to remind everybody that real consumers are affected by what we do and what we decide. So those of you who've had a big breakfast, you need not look at this, but I just want to point out the reality of table saw injuries. These are not paper cuts. These are not minor lacerations. These are very, very serious injuries. So if we vote no on this package, or if we delay the vote further, we simply increase the number of injuries like these that will not be addressed, and I would view that as very sad and unfortunate. I think the staff has made an overwhelming case for publishing this NPR. I realize that there are various concerns that have been raised about our vote today, and I'm prepared to address those as appropriate. Thank you, Madam Chair.
Thank you. Commissioner Robinson?
I have no questions. Thank you.
Commissioner Kaye?
Thank you, Madam Chair. I just want to thank the staff and echo what Commissioner Adler said. You really did a phenomenal job, and I believe the package is ready to go, and I look forward to supporting it. Thank you.
Thank you. Commissioner Mohorovic?
No questions at this time, Madam Chairman.
Having heard no further questions, staff is excused from the table. That's right. We are now going to consider any amendments or motions. Does anyone have any amendments or motions?
I have 2 motions and 2 amendments, Madam Chair.
I will recognize Commissioner Robinson for her motion, and I will ask you to describe it with for up to 3 minutes, and then after the conclusion of that, I will ask for a second. Commissioner Robinson.
My first motion is to direct staff to commence a study of the type of table saws involved in 2016 incidents. As we discussed at the briefing, currently we do not have information about the types of saws involved in our incident data. This information may make a significant difference in the formulation of a final rule. To date, we've obtained substantial information about the 2017 incidents. However, I'm convinced that we should at least try to obtain objective saw-type information from the NICE 2016 incidents. To that end, we've worked with staff very hard to figure out the best way to do so, and I really want to thank OEX and EXHR particularly for working with us on this motion. I'll read the motion and then explain it further. The Commission directs staff to contact individuals who suffered table saw blade contact injuries reported in NICE between January 1, 2016 and December 31, 2016 for the sole purpose of collecting objective information regarding the type of table saw involved in the incidents. Staff will provide the Commission a written report on the status of the project no later than August 15, 2017, which shall include but shall not be limited to a report on the number of individuals for whom staff has obtained contact information from NICE hospitals, the number of individuals staff has successfully contacted, and a summary of the information received from these individuals. After receipt of staff's written report, the Commission will determine whether to instruct staff to continue the survey and publish the results in the Federal Register for notice and comment. I want to quickly focus on three aspects of this motion. It will provide potentially invaluable information. I firmly believe that this motion directing staff to attempt to obtain SAW-type information using the 2016 NICE incident data is necessary and integral to publishing this NPR. This information may be easily obtainable. It is perfectly possible, and I indeed believe probable, that most of the people injured still own the saw involved. None of us knows until we try. If staff is able to collect objective data related to saw type from the 2016 NICE patients, this information may dramatically impact the cost-benefit analysis, which would help make the Commission's decision on this rulemaking much better and much more informed. And I'd just like to say that this is a very limited ask. We have 1,300 NICE patients in the NICE data who suffered blade-related injuries. We have a limited ask of each of those people. We just want to know objective evidence of what type of saw it was. We don't care if they text us a picture. We don't care if they tell us the make and model number, give us the instruction manual, or receipt from the purchase. Staff will determine the methodology, and then staff will give the Commission an update in 3 months, and we can decide if we should go further. Thank you.
Thank you. Having heard Commissioner Robinson's motion, do I have a second?
I second it.
Having heard a second, we'll now move to consideration of Commissioner Robinson's motion. Commissioners will ask their questions, and then we'll come back to Commissioner Robinson at the end, unless any of the commissioners want to yield their time during the course of their questions. Each commissioner will have 5 minutes per round. And I will begin with myself. Commissioner Robinson, have you talked with staff about the impact that this 16 study would have on the 17 study that we are doing to obtain the national estimate?
We have, and my understanding is that it will have no impact whatsoever, that they will still proceed with the 2017 data that they're collecting.
Thank you. I have no further questions. Commissioner Adler?
Thank you, Madam Chair. I'm going to support this motion, but I'm going to do it very reluctantly. It's not that I object to gathering additional data, but to me the data has to be useful, and the data gathering has to be within available Commission resources. I remember the briefing that we had when this issue was first raised. Staff then responded in a memo dated April 3rd, in which they said, based on their careful technical review of the proposal by their senior statisticians, they concluded that this study would be neither statistically sound nor defensible. My understanding is staff has not retreated from this position, and I find nothing new in Commissioner Robinson's arguments today that persuades me to the contrary. That said, I'm prepared to, in the spirit of compromise, to support this, and therefore I will vote for the motion.
Could I respond?
If Commissioner Adler will yield his time.
I will.
The idea that we would not even try to find out the type of saw involved in a whole year's worth of incidents is a bit mind-boggling to me. And we don't know if this is going to be statistically significant, because unless we try, we cannot know. And that's what the purpose is of the 3-month report back, because we could very well find that every single one of these people know what type of saw they had, and it could be. If we don't try, we won't know. But I very much appreciate your support.
And reclaiming my time, if this were the only thing before the commission, I would certainly agree with Commissioner Robinson. But the fact is, we know that the staff is engaged in undertaking a study of 2017 data that staff is absolutely confident will give us statistically representative data. And it is not my understanding that the impact on resources for gathering the 2016 data will be zero with respect to the 2017 data. I am assured, however, that it will be minimal, and for that I'm grateful.
Thank you. Commissioner Kaye?
Thanks, Madam Chair. I share some of Commissioner Adler's concerns. I also share staff's concerns and don't buy into the false premise that we need this data, that it's critical for moving forward with the NPR. I do believe that the analysis that is contained in the NPR is more than sufficient, and so for that reason, I'm not sure if I will support the motion. Thank you.
Commissioner Mohorovic?
I have no questions.
Thank you. Commissioner Robinson, do you want to respond to any of those questions?
I would only say that had this been raised with all of the commission back when this deficiency in our data was first brought up, I wish that it had been. I think we could have all cooperatively and proactively addressed this. I've come up with, and talking to staff, I've come up with the best solution I can come up with for trying to get this data as quickly as possible so we have some information. And I strongly disagree that this is not a deficiency in the package, as is repeatedly said throughout the package, that without data of the type of saw involved in incidents that we really have a problem. And as we all know, any rule we pass is going to be subject to judicial scrutiny.
Thank you, Commissioner Robinson. Do any of the other commissioners have further questions? Having heard no further questions to Commissioner Robinson, we will move now to vote on the motion. Commissioner Adler, how do you vote?
I vote aye.
Commissioner Robinson?
Aye.
Commissioner Kaye?
Aye.
Commissioner Mohorovic?
Aye.
And I vote no. The yeas are 4 and the nays are 1. The motion by Commissioner Robinson has been approved, not passed. Are there any more, approved. That's just an editorial here in my notes. Are there any more amendments or motions?
I have a second motion, Madam Chair.
Commissioner Robinson, I will recognize you again for your motion. You have up to 3 minutes to describe it, and then we will follow with a second for the motion.
My second motion relates to the current work being done to analyze the 2017 NICE incidents that involved table saw blade contact injuries. This work involves CPSC field staff contacting NICE patients and visiting them in their homes to fully understand the nature of the incident and injury, as well as identify the saw type. This work is also critically important in order to pursue this table saw rulemaking under our statute. My motion reads as follows. The Commission directs staff to analyze and seek public comment on the table saw study started in January 2017 based on the most appropriate time period that will generate information to determine a national estimate from NICE incidents. Results will be published in the Federal Register for notice and comment as part of the docket for this rulemaking. If the table saw study is completed based on incidents occurring in 2017, the results will be published on or about August 1, 2018. If the table saw study must be extended into 2018 in order to generate sufficient information to determine a national estimate, the results will be published on or about August 1, 2019. I believe this motion is necessary to make the findings required for the final rule for table saws. For that reason, I want to ensure that these results are included as part of the public rulemaking record and that all of our external stakeholders have an opportunity to comment on these results. The reason for the different dates is that the first date of on or about August 1, 2018 is based on staff's projection of when field work of contacting NICE patients will be completed and when table saw study will be completed. The second date, a year later, is included simply because if staff staff is unable to contact enough NICE 2017 patients to generate a national estimate, then staff may need to include incidents from NICE 2018, which will require waiting to receive the NICE weights from 2018, which does not happen until a few months into the calendar year 2019. I'm very hopeful that this table saw study will provide the CPSC with exactly the type of detailed information needed about table saw incidents, including the type of saw responsible for the injuries. This information will assist staff in making a robust recommendation in the final rule, including enhancing the cost-benefit analysis and better informing the scope of the mandatory standard. I'm happy to answer any questions.
Thank you, Commissioner Robinson. Is there a second?
Second.
Having heard a second, we will now move to consideration of Commissioner Robinson's motion. I will begin with myself for questions. I have no questions. Thank you. Commissioner Adler?
I have no questions. I am going to support this motion. I do think that Commissioner Robinson has done a good job of describing that which the staff had announced they were going to do, but I think to put it into the Federal Register notice is probably a good idea, so I certainly plan to support it.
Thank you. Commissioner Kaye?
I have no comments or questions. I plan to support it. Thank you.
Commissioner Mohorovic?
No questions.
Commissioner Robinson, do you have any further? Thank you. Having heard no further questions to Commissioner Robinson's motion, we will vote on the motion. Commissioner Adler, how do you vote?
I vote aye.
Commissioner Robinson?
Aye.
Commissioner Kaye?
Aye.
Commissioner Mohorovic?
Aye.
And I vote aye. The yeas are 5, the nays are 0. The motion by Commissioner Robinson has been approved. Are there any other, are there any other amendments or motions?
I have an amendment, Madam Chair.
Again, Commissioner Robinson, I will recognize you for your amendment, and I will ask you to describe it for up to 3 minutes, and then after the conclusion, we will ask our questions.
Thank you. I will not read the contents of the amendment because it has been circulated to all of the commissioner offices, but this is an amendment to include in the briefing package a discussion about RAND. The rulemaking process concerning table saws has been a very long and complicated one, both within the ANSI UL voluntary standards process and here at the CPSC in the mandatory rulemaking process. One of the hugely complicating factors in both of these processes has been that a performance standard such as that proposed in this NPR could potentially require the use of a patented technology known as active injury mitigation, AIM technology, owned by Dr. Stephen Gass and SawStop, making the patents that apply to that technology what are called standard essential patents, or SEPs. UL and ANSI both have patent policies that require a reasonable and non-discriminatory, that is RAND, commitment made between a patent owner of an SEP and the standards organization before a standard potentially requiring the use of an SEP will be implemented. A RAND commitment by the holder of an SEP states that the patent holder either does not hold any essential patent, or if they do, the patent will be licensed to applicants under reasonable terms and conditions, either with or without compensation. Under the voluntary standard, manufacturers would be third-party beneficiaries of that commitment and could file a lawsuit if they could not agree upon a rate so that a court could determine what an appropriate RAND would be. As I understand it from this package, public documents and various conversations, the voluntary standards process for table saws has been very contentious. I would not be presumptuous enough to take a position on the merits of the different positions, but to suffice it to say, SawStop did not provide UL with a RAND commitment covering its patents during the voluntary rulemaking process, and the UL voluntary standard does not include a performance standard that would potentially require AIM technology. So now we are engaged in mandatory rulemaking, where we do not have statutory authority to require a RAND commitment. The briefing package discusses the potential effects that approximately 100 patents held by Dr. Gass and SawStop could have on passing a mandatory safety standard, including the cost-benefit analysis. I believe it's important to also include in the package a discussion about the UL and ANSI patent policies requiring a RAND commitment from any essential patent holder. My second amendment, which I'll discuss shortly, adds questions that are very important to the policy decisions we as a commission will have to make before passing a final rule.
Thank you, Commissioner Robinson. Is there a second?
Second.
Oh, go ahead.
Commissioner Kay, second.
Yes, Madam Chair.
Thank you. Having heard a second to Commissioner Robinson's amendment, we will now move to any questions the commissioners might have. I'll begin with myself. I do not have any questions, but I do want to thank Commissioner Robinson and her office for the tremendous amount of work they've put into this issue and inquiries and research into this whole issue of patents. And so I thank you for that work, and I think this is a valuable addition to the package, and I look forward to supporting it. Commissioner Adler?
At the outset, I guess I'm a little confused. Which amendment are we looking at? There's one that's called Voluntary Standards and Patent Policy, and there's one that's called Binding Rent Commitment. Which is the one that's before us?
We're hearing the amendment, hang on. Hearing the amendment, which one?
Okay, I'd view. Okay, that's one I'd viewed as the Second Amendment. I'm going to vote in support of this motion because it simply adds a bit of information to the briefing package. But that said, I think it sends the wrong message to the regulated community, to consumers, and to the world. FRAND agreements are voluntary agreements within voluntary standards development efforts, and I'm not sure it's terribly relevant to our vote today on an NPR. I would point out that neither UL nor ANSI has ever determined that AIM technology constitutes a standard essential patent, and SawStop still vigorously disputes this technology fits within that category. I'm not prepared to say that it is not a standard essential patent. I just think it's somewhat irrelevant to the issue before us. And I would also note in passing that although UL has raised the issue of standard essential patents, they nevertheless permitted SawStop to participate fully in the revision of the current voluntary standard and to vote on its adoption. And as I will explain in response to Commissioner Robinson's next motion, the votes by the industry against AIM technology have had almost nothing to do with whether or not SawStop was willing to sign a FRAND agreement.
Thank you. Commissioner Kay?
Thank you, Madam Chair. I plan to support it, but I have the same concerns that Commissioner Adler does, and he summed them up very nicely. Thank you.
Commissioner Mohorovic?
No questions, thank you.
Thank you. Commissioner Robinson, would you like to respond?
Yeah, when you look at the definition, I think that, I will just say that I think Commissioner Adler is very confused on what essential patent means. It simply means that a patent may, not must, but may be required, the technology under a patent may be required if a standard is passed. And the point that I think, and I'll discuss it further with respect to my Second Amendment, but the point is the voluntary standards at this point, and the language for ANSI was just changed, and the UL is consistent with this, so that they've added it as a mandatory, not should, but shall require a patent holder whose patents may be affected by a rule to both disclose all of them, going to Commissioner or Chairman Burkle's first question, to disclose all of them and to make a RAND commitment, or they won't pass the voluntary standard. And the question that presents itself from a policy perspective is pretty obvious. So we're in a mandatory rulemaking process, and I've had multiple conversations with people from multiple agencies about this, but we're very unique in this particular situation, and I'll explain why later. But the point is, in the mandatory rulemaking, even though we don't have statutory authority to require it, neither does a voluntary standards process, do we as a commission want as a policy to do something on a mandatory basis that the voluntary standards bodies would not do without a RAND commitment? And are we protecting consumers by doing that? I just think whatever your answers to those questions are, they're very, very relevant as a policy matter.
Thank you, Commissioner Robinson. Commissioner Adler, do you have?
Yeah, I don't think I'm very confused about what a FRAND agreement is whatsoever. I'm simply making the point that neither ANSI nor UL has declared this to be a standard essential patent. But on that point, I'm perfectly willing to assume for the sake of argument that this is the only way to comply with an NPR before us. So I don't really see that as an issue. That doesn't mean, And that's my point. That doesn't mean that CPSC should be insisting that there be a FRAND agreement for our rulemaking.
Commissioner Kay?
No further comments or questions, thank you.
Commissioner Mohorovic?
No questions, thank you.
Having heard no further questions, we will now move to vote on Commissioner Robinson's amendment. Commissioner Adler, how do you vote?
I vote aye.
Commissioner Robinson?
Aye.
Commissioner Kay?
Aye.
Commissioner Mohorovic?
Aye.
And I vote aye. The ayes are 5, the nays are 0. The amendment by Commissioner Robinson has been approved. Are there any other amendments or motions?
One more, Madam Chair.
I will recognize you for your amendment for 3 minutes.
I have an amendment. Got my speaker on. As I've said, this NPR is unique to this agency in that the proposed safety performance standard may require the use of a standard essential patent for which there is no RAND commitment, and we have no statutory authority to require one. My staff and I have had a number of very informative discussions with CPSC staff, UL, ANSI, other government agencies, antitrust attorneys, and even an antitrust professor. My understanding from those discussions is that ours is a highly unusual situation, not only within this agency, but within government more generally. The issue of a RAND commitment in the mandatory standards environment has most often come up with respect to cell phone technology. And in those cases, the parties have been able to work out compromises for sharing their technologies so that the mandatory standards body doesn't need to consider it. Requiring a RAND commitment, as the voluntary standards organizations do, while I said it's beyond our statutory authority and it would raise serious takings issues, however, giving serious consideration to whether we as an agency should pass a mandatory rule where a voluntary rule could not be passed is a very important policy decision by the agency. In addition to voluntary standard development organizations, we know that other agencies such as the FCC and the FTC have considered this issue in different contexts, and I believe this is an area in which we need as much information as we can get to determine what our policy should be going forward. I believe that although it's unique to this agency at this point, technology is advancing at lightning speed, and we will most likely face similar issues in other contexts, particularly in the high-tech area. While our top priority is consumer safety, our statute requires a cost-benefit analysis that cannot be properly done if we create essentially a monopoly over which we have no control. We may even learn in this process that we need to ask Congress for more authority regarding patent issues, or that we should engage differently with voluntary standards committees when essential patents are an issue. These are the policy questions we need to be thinking about as we move forward on specifically this rulemaking, and also more generally as we think about our allocation of resources and how to meet the goals of our strategic plan. This is an opportunity for the Commission to gain more information about if and how a RAND agreement could benefit consumers and help us make a more informed decision. Finally, I strongly just want to encourage everyone, consumers, manufacturers, patent lawyers, anyone with information, to submit their comments and participate in the public hearing we will hold as part of this rulemaking process.
Thank you, Commissioner Robinson. Is there a second?
Second.
Having heard a second, we will now move to consideration of Commissioner Robinson's amendment. Again, commissioners will ask their questions, and then we will come back to Commissioner Robinson at the end to yield her time for answers. I have no questions at this time. Commissioner Adler?
No questions, but a comment, and I do want to make clear that gathering additional information is fine with me. I was trying to remember in the years I've been at the Commission if I've ever opposed a Commissioner's request that we add requests for information. I can't think of one. I certainly don't plan to do that today. But what I want to say is I have deep reservations about what I suggest to be the underlying assumption of the amendment. And that is, the underlying assumption is that we should insist on SawStop signing a FRAND agreement in order for us to move forward on a mandatory standard. I think if we did that, we would bring this whole proceeding to a grinding halt, because then we would really have no basis for doing a cost-benefit analysis. I remind folks that FRAND agreements are voluntary. In voluntary standards proceedings, they are designed to prevent patent holders from seeking abusively high monopoly profits, not monopoly profits, but abusively high monopoly profits, or unfairly withholding vital technology from competitors, neither of which is present in this case. They don't set specific terms. They only commit parties to negotiate the terms. The problem is if we insisted on such an agreement in this case, we would guarantee endless years of uncertainty and litigation, since, to say the least, no one in this industry is in any rush to adopt AIM technology. To the contrary, as we've seen time and time again, the industry has consistently cast negative votes against AIM technology because virtually all of the table saw manufacturers continue to insist that their existing standard is adequate, which it's not. They clearly believe it's in their best interest to drag the process out forever, or at least until SawStop's patents have expired. To me, FRAND is simply a delaying tactic. FRAND issues have never been the basis for industry's opposition to AIM technology. Their opposition is to AIM technology, not to the lack of a FRAND agreement. And I repeat, if we required a FRAND agreement, that would bring this proceeding back to square one, because then we really would be unable to do a cost-benefit analysis because we wouldn't know what the implication of the royalty cost would be on AIM technology. That would be the death knell of this proceeding. And let me just mention what SawStop has done. In effect, forgive the metaphor, they've cut to the chase, because for the past 14 years, they've told the world what their royalty fee would be. And they've made very clear that this would be available to any and every company that wishes to adopt it. There's no need, in my view, for a FRAND agreement because we know what the royalty fee will be. And we know that SawStop will license its technology to anyone who would want to meet the standard. Staff has looked at their licensing fee, and they've determined it will add at most about $37 to $57 for bench saws, which are the most price-sensitive model, and they found no basis for concluding that these added costs will undermine the competitiveness of this industry. That determination is our task under CPSA, not calculating or insisting on a FRAND agreement. So I don't see the need for a FRAND agreement. There's no discrimination among buyers. There's no need for us to pick winners and losers. There's no ambiguity. There's no uncertainty. There's no endless litigation, and there's no delay. But in the spirit of compromise, I repeat, I'm willing to support this because it's seeking additional information. I just don't like the underlying assumption.
Commissioner Kaye.
Thank you, Madam Chair. As a matter of deference to a colleague, I do plan to support this amendment, but I do have grave concerns about the underlying policy. I feel 7 and 9 are burdensome enough as a statutory regime for us to follow. I don't see how it is in the interest of consumer safety to voluntarily layer additional hurdles onto those requirements. Thank you.
Commissioner Mohorovic.
I have no questions.
Commissioner Robinson, would you like to respond?
I would. It's hard to know where to start because there are so many erroneous assumptions in what Commissioner Adler says. There is no underlying assumption that we should insist on a RAND commitment because we have no statutory authority to do so. And yes, a voluntary standards body does not insist on a RAND commitment. What they say is, we're not going to pass a standard that would require or may require using your patent without a RAND commitment. That's the quid pro quo. And obviously, SawStop doesn't have to make that commitment, didn't, and UL didn't pass a standard that required AIM technology. So what we're doing here, first of all, let me back up and say, this is the first time this as a policy has come before this commission. I've spoken with our people on staff. We have had one tiny blip of maybe this will be an issue in one other rulemaking process, and it didn't end up being an issue. So the idea that we as a commission wouldn't consider whether we would do something on a mandatory basis that the voluntary standards bodies will not do seems rather short-sighted, to say the least, that we wouldn't even consider this. And let me just say that the way that RAND commitments work is we don't determine what the fairness of the amount is, and one unilateral party doesn't get to determine what that is. I don't know if SawStop's First of all, it's not a RAND commitment, so there's no third-party beneficiary, so a manufacturer could not seek to enforce that. That's number one. But number two, I don't know if it's fair or not. I wouldn't pretend to know if it's fair or not. The point is that if the parties don't agree on it, if there's a RAND commitment, then the manufacturers are third-party beneficiaries of that contract, and so they may bring a court action, and a court then decides whether it's fair. And for example, I happen to know from my tiny bit of patent law that I know, the people who seek patents, for example, a jewelry designer, will do a patent including the diamond that's in the design, so that the fee will be higher. Well, I understand that there is some contention around whether the full value of the saw is what should be used for the 8%, or what's being added to the saw. I don't pretend to have the answer to that. But the point is, we would be getting out of the process, and a court could decide that if the parties can't decide. If this wasn't complicated, I am absolutely certain that the UL process would have sorted this out. That's where this kind of thing should be sorted out. But I come back to, we as a commission are considering doing on a mandatory basis what a voluntary body would not. At an absolute minimum, we should get the information from other agencies, other people who've been involved in similar situations, and decide if this is something that we as an agency want to do as a matter of policy.
Thank you, Commissioner Robinson. Do any of the other commissioners have questions? Commissioner Adler?
No, just a quick response. I'm delighted to hear Commissioner Robinson say that there's no underlying assumption in her amendment. I believe anybody reading it would read a clear implicit message there that we should do something and require something with respect to a FRAND agreement. If that's not the case, I'm delighted to hear that, but that's not the implication I drew from reading her amendment. And I do think that the point about court is a good one. If we went to 10 federal courts and ask them about what a FRAND agreement should be in this case, I think there's no doubt we'd get 10 wildly divergent rulings, both as to the proper formula and what a proper royalty fee would be. In other words, you're talking years and years and years of litigation, which simply then conspires to keep us from moving forward to do a mandatory standard. The staff has applied the proper test. You are correct. The proper test can be found in Section 9. That is to ask whether this royalty fee would impose an adverse impact on competition. I think it's pretty clear from what the staff has said is that it would not. If there's going to be a problem with the industry adopting AIM technology, it's not going to be the royalty fee. It's probably going to be the retooling costs. This is an entirely reasonable cost-benefit analysis, and if we didn't have a figure to use in our calculation, we would be bogged down and stuck at square one. So that's my concern. But seeking additional information on a neutral basis, I have absolutely no problem with.
Commissioner Kaye, any further questions?
No, thank you, Madam Chair.
Commissioner Mohorovic?
No questions.
Commissioner Robinson?
I only need to add that this is so short-sighted for Commissioner Adler to think we shouldn't even think that this is an issue in these circumstances.
Are there any further questions from the commissioners?
No.
Having heard no further questions to Commissioner Robinson's amendment, we will move to vote on the amendment. Commissioner Adler, how do you vote?
Aye.
Commissioner Robinson?
Aye.
Commissioner Kaye?
Aye.
Commissioner Mohorovic?
Aye.
And I vote aye. The yeas are 5, the nays are 0. The amendment by Commissioner Robinson has been approved. Are there any other amendments or motions on the table this morning? Having heard no further amendments or motions, we will now turn to the final vote on the proposed rule, safety standard addressing blade contact injuries on table saws. We will have time for closing remarks, but at this point, does anyone wish to be heard on this topic?
Before closing arguments, no.
Commissioner Robinson?
Thank you, Madam.
Commissioner Kaye?
No, thank you.
Commissioner Mohorovic? And I have no comments. Having heard no further comments, we will now turn to the vote on the underlying package. That is the proposed rule safety standard addressing blade contact injuries on table saws. Commissioner Adler, how do you vote?
Aye.
Commissioner Robinson?
Aye.
Commissioner Kay?
Aye.
Commissioner Mohorovic?
No.
And I vote no. The yeas are 3, the noes are 2. The proposed rule safety standard blade contact injuries on table saws has been approved. We will now turn to closing statements. Each commissioner will have up to 10 minutes for those, and I will go first. I regret the Commission's vote today to approve publication of a proposed standard for table saws. I believe the proposal is defective and does not merit approval at this point. The major shortcomings relate to 1, the scope of the standard, and 2, the lack of assurance that manufacturers will be able to license the technology needed to meet the standard on reasonable terms. I'll first talk about the scope of the standard. The notice of proposed rulemaking points out that there are 3 distinct types of table saws. Some are portable, some are not. Some run on ordinary household electric wiring, others cannot. Some table saws are 25 times more expensive than others. This leaves a burning question. How do the different types of table saws differ in terms of injury rates? Does it make sense to apply the same performance requirements to all of them or not? To help answer that question, in 2007, the CPSC staff designed a special study of table saw injuries from the NICE system. The goal was to discover which types of table saws was responsible for each injury, and then develop a national estimate for the proportion of table saw injuries attributable to each type of saw. Unfortunately, the results of the study weren't made public until 2011, and as details finally became known, commenters pointed out that the results were internally inconsistent and could not be used to classify injuries by saw types. Given the importance of this issue, then staff designed another NICE study in 2014. However, this study also failed to shed light on which type of table saw was responsible for the particular injuries. The NPR explains why it might not be appropriate to apply the same standard to 3 different types of saws. And I quote from the NPR, "Because of the difference in the physical characteristics, to use patterns and the likely population of each user of the table saws, that is, bench, contractor, and cabinet saws, an independent evaluation of the benefits and costs for each type of saw could be useful. For example, the cost of the proposed rule could exceed the benefits for 1 or more saw types, even though in aggregate, benefits could exceed the costs for the market as a whole." The staffs continued with their persistent efforts to develop injury estimates for each type of saw underscores the importance they assign to this matter. Indeed, despite the prior setbacks, staff has launched a 3rd special study following up all NICE table saw cases as they reported through 2017. And today the Commission has also directed staff to look at the 16 injury data as well. Nevertheless, the Commission majority refuses to wait for the results of those studies, proposing a standard. The result is a one-size-fits-all proposal that glosses over the differences among the table saws in a broad category. In my view, this approach is a serious mistake. As the staff has long recognized, promulgating the same standard for 3 types of table saws may well impose costs that are not justified by the benefits. The proposed generic standard is expected to wreak havoc in the table saw market. The staff predicts that some saws will more than double in price, and other manufacturers will exit the market. Under these circumstances, the Commission should not be taking shortcuts, but getting the data that it needs to make responsible decisions. My colleagues say that we can take a 2-track approach, securing the public comment on the generic saw data, and at the same time we develop the data for 16 and 17. Thankfully, they do contemplate, and it was voted on this morning, a 2nd round of comment when the necessary data became available. In my view, however, we should know the answers to those questions before we shape our proposed rule. My second concern has to do with creating a monopoly. The second serious problem with the proposed standard is it almost certainly would require the use of patented technology, and the Commission lacks sufficient assurance that the patent holder will license the technology on a fair, reasonable, and non-discriminatory terms. In fact, we may be granting a monopoly in favor of one company that could control the supply of table saws and charge whatever it would like without any effective competition. In essence, the proposed standards requires table saw manufacturers to incorporate Ames system. An Ames system performs two distinct functions. Number one, it must detect actual or imminent human contact with the table blade saw. Number two, it must react by stopping the blade or by taking other action to prevent a serious injury. SawStop first introduced the AIM technology on the table saw in 2004, and on a number of models thereafter. The firm's principal, Dr. Gass, and the affiliated entity, SD3 LLC, reportedly hold over 100 patents that relate to AIM technology on table saws. No other manufacturer has even attempted to introduce a table saw employing AIM technology until Robert Bosch finally did so in 2016. Dr. Gass promptly sued him in federal court for patent infringement and separately asked the International Trade Commission to block importation of the Bosch saw on that basis. Thus far, that effort appears to be successful, leaving SawStop as the sole provider of table saws employing the AIM technology. In recent years, UL has proposed to AIM performance requirements to the voluntary standards for table saws, UL 987. In the NPR approved today, it is reported that the effort failed because the table saw industry objected to making the AIM requirements as part of the UL standard. This doesn't tell the whole story. During development of the voluntary standard, members of the standards technical panel advised UL that the proposed performance requirements, much the same as our CPSC proposed standard, implicated SD3 patents. Pursuant to its patent policy, the UL asked Dr. Gass to, quote, identify the specific patent claims that are essential for compliance with the AIM requirements, end quote. And with respect to all such claims, confirm that a license will be made available to applicants desiring the license for the purpose of implementing the standard under reasonable terms and conditions that are demonstrably free of any unfair discrimination. In response, Dr. Gass raised a number of objections to UL's request. Among other things, he argued that the proposed voluntary standard was a performance standard, not a design standard, and therefore would not necessarily require table saw manufacturers to adopt that technology. He stated that SD3 declines at present to provide any type of statement concerning its patents, other than to say SD3 reserves all its patent rights. UL's proposal did not achieve consensus. The Power Tool Institute opposed the AIM technology to the voluntary standard for several reasons. The first stated was that after years of research, the only known technology for meeting this standard, quote, may be covered by standards essential patents that are not likely to be licensable, quote, on reasonable and non-discriminatory terms. In other words, UL's proposal to add AIM technology to the voluntary standard might have made it impossible for any other manufacturer other than SawStop to comply. In the present situation, the Commission is proposing a standard that is very much like UL's failed voluntary standard. Like UL, the Commission has no assurance that manufacturers will be able to meet the proposed standard without infringing on SawStop's patents, or that SawStop will be prepared to license that technology on reasonable terms. At the staff's briefing on the table saw NPR, one of my colleagues claimed that Dr. Gass has in fact pledged to license the AIM technology. He pointed to SawStop's 2003 petition asking CPSC to mandate AIM technology. Others have criticized the 2003 licensing offers as unreasonable. When my staff and I recently met with Dr. Gass, moreover, he made it clear that he would no longer stand by the 2003 offer without additional conditions. According to PTI, some manufacturers have tried in recent years to negotiate licensing agreements with Dr. Gass, but met with escalating demands and outright refusals. Under these circumstances, I'm not at all comfortable with the proposed standard. I do not begrudge Dr. Gass the royalty he is due for his original ideas. but neither do I want to be a part of to the proposal that gives him a blank check to monopolize the table saw market. I think that before proposing a table saw standard, we should clearly understand the extent to which manufacturers are dependent on patented technology and the willingness of the patent holders to grant licenses on fair, reasonable, and non-discriminatory terms. Thank you, and Commissioner Adler.
Thank you very much, Madam Chairman, and thanks again to staff for developing such a highly complex and technical NPR package. You've done yourselves proud with such a superb piece of work. We've walked through the various issues relating to table saws, and I don't want to revisit all of them if I don't consider them central. I did want to comment on the monopoly issue. With respect to the license fee, as far as I can tell, and as far as I can determine from talking to Dr. Gass, he's never retreated from his offer to license this at this specific number. And we have an enforcing mechanism for that, because there will be a period of time between the date of promulgation and the effective date. Should he in any way change the terms of his license fee, then the Commission's operating assumption in the briefing package would be rendered invalid, and I would, at that point, vote to withdraw it. So I think we have a good policing mechanism, but I have absolutely no reason to assume that he would in any way change the amount of licensing fee, and he has made absolutely unequivocally clear that he would license it on a non-discriminatory basis. So the fact that there was no consensus, I repeat, had almost nothing to do with the FRAND agreement. It had to do with the fact that the industry just doesn't want to adopt AIM technology. But I want to come back to some of the points that I think are so essential to this vote. And I have to start again with the fact that table saw injuries are numerous and horrific. And I want to remind folks about a young man named Josh Ward who testified at our priorities hearing. He's the young man who described his injuries to the Commission at our priorities hearing by pointing out that his left hand had a terrible, terrible table saw accident. And this is what it entailed: an initial 12-hour surgery with 2 hand surgeons. In addition to the permanent loss of 2 fingers, he lost 50% of the function of his remaining fingers despite 3 additional surgeries in 7 days. And there are terrible long-term effects of infection and loss due to cut nerves and loss of blood flow. He's already had a 2-year-long bone infection that required 10 rounds of antibiotics and 180 hours of hyperbaric oxygen therapy. Just thinking of that curdles my stomach. This is all at a cost so far of $350,000, and sadly, that is typical of amputations in table saw injuries. On the good news front, and I think it's really good news, it seems to me there's little doubt that AIM technology will dramatically reduce, if not eliminate, almost all table saw injuries. In my experience, it's rare for the Commission to encounter such an impressive single step forward for safety. AIM technology is awe-inspiring. Anyone who has observed it in action has to come away with an enhanced appreciation for the power of science and technology to improve our lives. And I think it's also fair to say that unless we take decisive action, I think it's unlikely that consumers will ever be adequately protected from table saw injuries. Table saws with AIM technology have actually been on the market for a number of years now, but they still constitute only a small fraction of the table saws sold in this country. And there's no reason to assume that this number is going to dramatically increase anytime soon unless we act. Sadly, most consumers simply don't understand or appreciate the very high risk of injury that exists every time they use a table saw. Staff has pointed out, casual users may be unaware of how quickly and violently an injury can occur. Staff has also noted, even consumers who are fully aware of the hazards and how to avoid them may suffer from slips or lapses that could easily lead to blade contact and injury despite the consumer's best intentions to use the product safely. And just one quick note on consumer misuse or abuse. There's no evidence in the record of consumers acting recklessly under the influence of drugs or alcohol. The point is, even careful, sober users can suffer catastrophic injuries from only the smallest and most human of lapses. And I will just also mention the notion of an education campaign. I think it's true that education campaigns can be a valuable supplement to our regulatory activities, but relying solely on education campaigns for table saws is going to be an exercise in futility. We and the industry have been warning about table saw injuries and hazards to no avail. And I want to make one final point because I assume my colleague, my esteemed colleague, Commissioner Mohorovic, is going to raise the point, and that has to do with freedom of choice in the market. And I agree in the main with the notion that we should give consumers freedom of choice, but it has to be a true freedom of choice, and that requires full information and appreciation of the choices before consumers. Simply knowing that a table saw can cut you is about as helpful as knowing that an airplane can fall from the sky. You need more data to properly assess the risk. And given the horrific toll year after year of table saws, even to experienced, careful users, I find it impossible to believe that providing more warnings and more instructions is going to do anything to solve the problem. To be truly safe on a table saw, you have to be perfect when you use it. Not every time, but perfect, and no one is perfect. I think there comes a time when society has the right to look out for the safety of its citizens, even when they might not do so themselves, because their injuries cost us as well as them. Table saw injuries cost between $160 million and $1 billion in direct, not pain and suffering, direct medical costs and lost wages. And we as a society share those costs either through higher insurance premiums or higher taxes or both. Given this, I think that we as a society at large have some say in table saw safety. Our vote means that these societal costs will be dramatically reduced and greatly offset by the benefits of fewer injuries. I remind everyone that we require drivers, even when they don't like it, to get licenses and obey traffic laws, including the requirement to buckle their seatbelts. We do so because we want our citizens to be safe and not to burden us and them with unnecessary fatalities and injuries. And Joe, I couldn't resist this. There's an article written a number of years ago by George Will, and it was in response to a former president's criticism about elites telling the public what to do and not relying on the wisdom of the public. And I thought Mr. Will's response to then President Reagan was telling, so I'm just going to read his response. A free market is a nifty arrangement for recording preferences and allocating resources accordingly. But there's a point at which obeisance of political persons before market decisions is like other forms of populace, an excuse for not leading. At that point, free market principles are less an aspect of their political philosophy than a substitute for political philosophy. The state is more than a device for serving the immediate preferences of its citizens. Its purpose is to achieve collective objectives, and the collectivity, the nation, includes a constituency of generations not yet born. That's why the state, unlike an economic market, has responsibilities and must look down the road further than citizens generally look in their private pursuits. Thus, the state's legitimate purposes are more complex than the sum of citizens' private purposes. The public interest is not just the automatic, unguided outcome of the maelstrom of private interests. I couldn't have said it better. I couldn't even said it half as eloquently. Thank you.
Commissioner Robinson.
Thank you. Let me first say that Chairman Burkle has very eloquently stated exactly what my concerns are about this package, and Commissioner Adler has very eloquently stated exactly what the problem is we have here in terms of the hazard that we're addressing. We all know that table saws pose a very significant hazard, and they have for many years, and we know that the numbers and the injuries are horrific. When you look at 2015 alone, there were an average of 11 amputations a day from table saws. And they're much more dangerous than other workshop products. We all know that. And we know that the costs that even our staff came up with were extremely conservative with respect to both the costs and with the economic losses and with respect to to the non-economic losses. And we've heard from many people as commissioners here who have suffered just enormous pain and suffering that comes with the altered life as a disabled person. And we know there's a technologically feasible way to prevent most of these injuries. And our staff estimates that if the standard that they've proposed was passed, that 70 to 90% of these injuries would be avoided. The proposed fix that they have is that the performance standard is that the blade, if it comes in contact with the finger, it can't go in more than 3.5 millimeters, which would make it much less likely to result in nerve damage, amputation, or other serious injuries. When you look at this and the estimates that staff came up with, that the table saw market as one single undifferentiated market, they estimate that the net benefits would be between $2,300 and $4,300 per saw, and estimates aggregate annual benefits could be between $970 million and $2.45 billion. Now, one would look at those, what I've just stated, and think this is exactly the situation that the CPSC should step in and mandate a performance standard that could prevent these injuries. And while these numbers sound very impressive, the problem is that, as Chairman Burkle has so well stated, when the bases for those estimates that are examined, there are critical missing pieces. And I don't for a moment fault staff for this. I really don't. I now know that they were instructed to go forward knowing that there were these deficiencies, and I don't fault staff for this. But the problem that I have is, if I were a consumer advocate, I'd have absolutely no problem whatsoever advocating for mandating a performance standard that requires the use of technology that would prevent these injuries. But I'm not that. I'm a consumer product safety commissioner. And anyone who's familiar with my work during the time that I've been a commissioner knows that I take my responsibility of protecting consumers from unreasonably dangerous products very, very seriously. And I work very hard at filling that responsibility. But I must meet that responsibility within the constraints of the laws and regulations that govern CPSC's decision making. That's the only way we can truly protect consumers. I would be doing consumers no favors whatsoever if I ignored the integrity of this agency and its required processes and simply blindly voted yes on a package that I believe contains potential deficiencies on the bases for the rulemaking, absent a concrete plan in place to correct any such deficiencies before final rulemaking. CPSC's regulations must meet the requirements of APA and CPSIA, or they may be overturned by the courts, as we so very well know, and CPSC also must answer to congressional oversight. In voting on rulemaking, I believe it's my duty to make every effort to make sure that a mandatory rule we pass will stand and not be overturned. What good does a mandatory standard do for consumers if it's not well-founded? I have some concerns with this proposed rule, as has become evident in my motions and amendments. In the cost-benefit analysis, in order for a final mandatory rule to withstand judicial scrutiny, we're required to do this cost-benefit analysis, which we've spoken of so frequently. As Chairman Burkle set forth to date, we simply have not succeeded in getting data showing the distribution of injuries associated with the three distinct types of table saws: benchtop, cabinet, and contractor. However, we know that because of the price point and the engineering involved, the proposed performance standard would have very different impacts on each of these segments of the table saw market. I'm particularly interested in these data of what kind of saws are involved, because we may find that injuries are not proportionally distributed across saw types. If so, it may make sense to pass a standard that covers only the types of saws that are associated with the highest number of injuries. We need to have this information in order to truly do an informed cost-benefit analysis for a final rule. And second, we have the essential patent issue. Currently, as I understand it, only one commercial product meets the performance standard proposed in the NPR. The company that sells this product has over 100 patents covering various aspects of the technology that would be required to meet this standard. The company's been very aggressive in protecting its patent rights and has succeeded in its litigation to stop the importation and sale of a competing product with AIM. And as much as this stance by the essential patent holder is perfectly legal, and I'm not for a moment being critical of it, this situation for us as an agency raises the very troubling prospect that by mandating this performance standard, CPSC would be doing something the voluntary standards community is unwilling to do, and that is pass a standard without an essential patent holder making a RAND commitment. The NPR package makes it clear that this situation would leave many unknowns on the disruption of the SAW market and the cost-benefit analyses. Today I propose 2 amendments and 2 motions that I hope will go a long way in addressing my concerns. I'm very happy to see they pass, and I thank my fellow commissioners for their support. I also thank their staffs, and especially OEX and EXHR staff, for working so closely with me and my office to help refine my proposals and to help address concerns that they raise. As I said, I share the Chair's concerns about this package at the stage where it is right now, but we are in the NPR stage, and so we diverge paths when it comes to the vote on this. I can say that I would not vote for a final rule with the package in this state, but I believe that these motions and amendments will do a great deal to strengthen the NPR, which I believe will go a long way to ultimately protecting consumers. They help to ensure that any proposed final rule will effectively address the hazard posed by table saws, will be based on a strong cost-benefit analysis with strong bases, and will be within the CPSC's statutory authority and withstand judicial scrutiny. With these motions and amendments, I'm comfortable voting for this NPR. The amendments related to the patent issues achieve 2 main objectives: clarifying in the package how this issue came into play with respect to the Voluntary Standards Organization, and secondly, in adding the questions, we're explicitly inviting information and opinions on this very, very unique situation involving an essential patent holder that may help the CPSC to advance safety without unduly impacting competition. The standard essential patent issue and mandatory rulemaking is a new one, as I've said, which may become a very important one as we go further. And I really seek input from other government agencies, standards development organizations, and anyone else, including patent lawyers and academics who may have information on this. Additionally, CPSC's decision on the best approach to potential standard essential patents in RAND could benefit consumers by making effective safety technologies more accessible and affordable. And hopefully the work CPSC does here today will help advance the thinking on these issues. I believe that the information that we're going to get from the table saw studies, the 2016 and the 2017, should help us have additional data to provide robust analytic support for the proposed rule. We simply must have this data, as Chairman Burkle stated, for us to come up with a final rule. I deeply regret that not all of the commissioners were informed many months ago that the study on the types of saws involved in blade contact injuries could not be relied upon. Had I been informed of this development, I would have made every effort to work together with the other commissioners and staff in a proactive way to find a solution before the enormous effort was put in by staff on this NPR as it's presented with its deficiencies. But it is what it is, and we are where we are, and I believe that these 2 motions go a long way in addressing this lack of data. Once again, I want to thank staff so much for working with my office to refine the motions I introduced, and thank my fellow commissioners for their support. Table saws cause way, way too many injuries and amputations for the CPSC to ignore the hazard they present. It's important that we go forward, in my view, with this NPR, however, with the motions and amendments which will put us in a much stronger position, both with respect to our continuing work with the UL Voluntary Standards Committee and with respect to proposing a final rule. Thank you.
Thank you, Commissioner Robinson. At this point, I've been advised that I left out some critical language in the in how the language that was used in terms of passing the NPR. And Mary, if you could explain.
Okay, there are a couple of things, but the commission voted to adopt the NPR, and the staff actually understands in the normal course that that means publication in the Federal Register, and that's how we would have proceeded if, as a matter of official record, you want to have a vote to publish in the NPR. That would be perfectly fine, but it was our understanding that publication was implied. If my memory serves, I believe you voted on underlying package, but not as amended. That's probably something you might want to just clarify, although, again, I think staff understood that the publication would be of the package as amended, but as a formality, you might want to consider that.
Thank you very much, and I believe Commissioner Kay is willing to offer those motions.
Thank you, Madam Chair, and I do appreciate your accommodating this request. And thank you, Ms. Boyle, for scrambling after we asked the questions. I would move that the commission revote and this time vote to approve the package and as amended and to publish the same in the Federal Register. I make that motion.
Second.
Do I need to take, okay. Commissioner Adler, how do you vote?
Aye.
Commissioner Robinson?
Aye.
Commissioner Kay?
Aye.
Commissioner Maharovic?
No.
Was that a yes?
No. For the record, please.
And I vote no. The ayes are 3, the nays are 2, and the NPR will be published as amended in the Federal Register. Thank you very much. I now turn to Commissioner Kay for his closing comments, and thank you.
Thank you for that accommodation. Safe to say, this NPR was long overdue. Before getting into dry topics such as timelines and performance standards and regulatory requirements, it is important, I believe, to start with the human impact of regulatory inaction. While we hear a lot of fabricated outrage about the impact of regulations, there is far less genuine discussion about the real costs of a failure to act. On December 19th, 2012, more than 5 years ago, Josh Ward was in his high school shop class in Sisters, Oregon. He was helping as a teacher's aide to the workshop teacher who had asked Josh to cut a wood board into long strips for a class that taught students how to make guitars. Josh used the school's table saw, which was not equipped with the kind of safety features our rule would require. Something went wrong. Something that happens in American homes thousands of times a year. The board caught in the saw with such force that Josh's hand was pulled into the blade. At the same time, the board was thrown across the room so strongly that it punched a hole in the wall. Josh was rushed to the ER, where the doctor called it the worst hand injury he had ever seen, according to Josh's mom, Angela. Josh needed more than 1,000 stitches, endured more than half a dozen surgeries, lengthy physical therapy, went through 45 2.5-hour hyperbaric chamber treatments, lost all or part of multiple fingers, and had his dreams of being a firefighter potentially dashed. He and his family have paid a very heavy price, for sure, for something that existing technology can and should prevent. Sadly, though, Josh's story is not uncommon in the least. Tens of thousands of consumers each year are treated in hospital emergency departments for injuries associated with table saws. Day after day, week after week, month after month, year after year, these incidents keep occurring. What has not been happening, however, is much to genuinely address the hazards table saws present. The marketplace has spent many years making no across-the-board progress. CPSC staff, thankfully, has been evaluating the possibility of a performance standard to protect consumers who use table saws since at least 2003, when the first flesh-sensing devices were presented in a petition. The Commission requested its first briefing package in 2006, although even that little bit of progress was stymied by a loss of quorum at the Commission and political gamesmanship by individuals whose inaction put corporate protection over consumer protection. Due to the advocacy and hard work of my good friend and colleague, Commissioner Adler, the Commission renewed its efforts and focus on this issue and published an advance notice of proposed rulemaking in 2011. Contrived budget crises that maintain an artificially limited budget at the expense of consumer health and safety and the need to address other pressing safety issues have all impacted our ability to move forward with this rulemaking. Again, thankfully, though, CPSC staff stayed at it, and now we have an excellent and thorough performance standard to propose and upon which to seek comment. It is important to keep in mind, of course, that this NPR is not a final rule. The purpose of an NPR, obviously, is to provide notice to the public of our plans for potential rulemaking and give our stakeholders an opportunity to comment on those plans. Nothing in the APA or our own statutes prevents the Commission from publishing an NPR while continuing our work. If any of the issues cited as reasons to vote against publishing this NPR were truly fatal to this entire rulemaking, our staff would never have put it forward for consideration. This NPR is ripe for publication and comment. First, we're dealing with a very real hazard that has serious costs to society. As CPSC staff mentioned in the package, their analysis revealed an estimated 33,400 table saw-related emergency department treated injuries occurred in 2015. About half of all amputations associated with workshop products can be attributed to table saws. The annual societal cost associated with medically treated blade contact injuries exceeds $4 billion. Consider that number again. $4 billion in societal costs. That is a lot of Josh Wards out there experiencing real and long-term suffering. We all know table saws are dangerous. No one's saying otherwise. But the scenarios and actions that lead to amputations and other injuries are not always intuitive. Consumers cannot readily predict the many possible scenarios leading to distraction, such as unfortunate but predictable reflective motions of the hand into the blade's path or a loss of balance. Seniors may not realize how their reaction time, balance, and eyesight might have deteriorated over time. Even experienced woodworkers may get overconfident in their ability to control a cut and become too relaxed in their safety precautions. All of these scenarios are foreseeable. All of these scenarios keep happening, and the resulting devastating injuries are all preventable. Ideally, an adequate voluntary standard would have been developed long ago and would be substantially complied with, and today's vote would not be necessary. Clearly, however, the voluntary standards process has failed, and today's vote was necessary. Through the years, saw manufacturers have attempted to improve the blade guarding systems through the consensus process available in ANSI-approved standards development. These efforts made modular blade guards common on the latest generation of table saws. However, despite these and other advances, CPSC staff has noted in the package that its most recent analysis showed no discernible change in the number of injuries or the level of risk associated with table saws from the period of 2004 through 2015. Clearly, we can and must do better. In the absence of an effective voluntary standard, CPSC staff has produced an excellent and thorough briefing package that proposes a performance requirement based on the maximum depth of the laceration made to a surrogate finger moving at a 1 meter per second rate into a spinning table saw blade. The proposal is about as broad a performance standard as could be developed. The method of stopping the blade is not restricted in any way, nor is it a particular test method required to show compliance. Given the technological advancements of the last decade, it seems reasonable to employ automatic injury mitigation systems in table saws to prevent these foreseeable and debilitating amputations and lacerations that continue to cost so many so dearly. As expected, the cost of designing a saw with such technologies is not insignificant, but prices should decrease as more units are ordered and technology advances. And staff's analysis show that the potential benefits far outweigh the costs associated with table saw injuries. There is just no valid reason why we should not move as expeditiously as possible toward innovative solutions that could alleviate and in most cases completely prevent the pain and suffering endured by tens of thousands of people each year. As for the argument that the benefit cost analysis is somehow incomplete or unreliable because staff did not have information allowing them to hyper-parse the injury data by type of saw, I can only strenuously disagree with the logic of those detractors, both about the need for that level of specificity and with and how critical that analysis is. Detractors of the NPR with dramatic exaggerations tout grave data gaps as a fatal flaw. In reality, the analysis before us includes a thoughtful and statistically accepted break-even analysis that overwhelmingly points to incredible benefits to society. This issue is not a red herring. It is a school of crimson mackerel. There is one final false issue that needs to be addressed, and that is the intellectual property concerns raised today. Most new technological advancements are accompanied by intellectual property issues, but most of the patent and antitrust concerns being raised in this discussion are at best a distraction. They have little bearing on the issue of safety and are largely outside of the Commission's jurisdiction. As discussed above, the NPR proposes a performance requirement, not a design specification. A manufacturer's method of stopping the blade is not restricted in any way by this proposal, nor is any particular test method required to show compliance, as I mentioned. To the extent intellectual property issues may affect the benefit cost analysis, these issues are already raised and addressed in the NPR. It is at best baffling why anyone would buy into the false notion that we need to arbitrate patent issues as part of our rulemaking. Wrong agency and wrong stage of the process. That might be an issue at some point for the Federal Trade Commission. In closing, I'm very impressed with and proud of the thoughtful proposal that CPSC staff has put forward, and want to thank them once again for their hard work and perseverance on this issue. I also want to commend Commissioner Adler for his commitment to solving this problem. My principal criticism for those who oppose this rule is I've seen no plan B from you. Nothing at all to suggest any alternative to rulemaking that would genuinely address these hazards. Defer to the market is not anything close to an injury prevention strategy. If it were, Congress would not have felt compelled to establish the Consumer Product Safety Commission in the first place. If you have a genuine plan B, let's hear it now. There has been enough inaction, enough harm done, enough pain suffered by the Josh Wards. We owe it to them to see this through and end these tragic, life-altering injuries. And one final comment that I would make is to offer a specific, well-deserved thank you. Special assistants to commissioners often work in the background without much fanfare. But their work is critical to what we do, and often the public is not aware of their specific contributions. Today's vote is one of those times. I want to thank Boaz Green for his perseverance and commitment to finding a path forward. Boaz, well done. We would not have taken today's action without your contributions. Thank you for that on behalf of all those who will benefit. Thank you, Madam Chair.
Thank you, Commissioner Kay. Commissioner Morohovic.
Thank you, Madam Chairman. I'd like to address the elephant in the room. I want to talk about crony capitalism, rent seeking. This is the cloud that has overshadowed this rulemaking for well over a decade. And the question remains, is this an egregious example of crony capitalism and rent seeking? Someone manipulating government to provide them a government-imposed artificial competitive advantage. Crony capitalism often comes in the form of no-bid contracts, permits, grants, tax breaks, and yes, compelling the use of certain technology. So to quote The Economist, a formal economic definition for rent seeking is when the owners of an input of production, be it land or labor, machines, capital, or IPR, extract more profit than they would get in a competitive market. And cartels, monopolies, and lobbying are common ways to extract rents. Rent seeking can involve corruption, but it's very often legal. So the question is this an example of legal rent seeking? Here's the conspiracy theory. Dr. Stephen Gass, inventor, comes up with Ames technology that is unquestionably effective. He fails to license that technology to major saw manufacturers and instead enters the market with his own saws. But not just an inventor, also a patent attorney, Dr. Gass protects his IPR with what has been presented to the Commission as dozens of patents, and he's successfully used those patents in court and federal regulatory proceedings to stave off competition. Then Dr. Gass himself petitions the government, the CPSC, to mandate that his technology be used across all table saws. And the government goes along for the ride, as we just did, recommending that the government provide Dr. Gass with a complete monopoly over the table saw market, where he can either be the sole manufacturer or he can hold up all other manufacturers for whatever royalty payments he desires. So those are the facts that lead people to believe this may be an egregious case of crony capitalism or pure rent seeking. And those same folks believe that CPSC should be embarrassed for allowing itself to be so thoroughly manipulated by a greedy monopolist. But having thought about this a great deal myself, I personally don't buy it. I don't think the motivation is corrupt manipulation of government for financial gain. Yes, Dr. Gass has millions to gain if the CPSC grants him a monopoly. I just think that those supporting the rule, including Dr. Gass, simply wish to mitigate a hazard they see as preventable through this technology. And after 15 years, I finally had the opportunity to meet Dr. Gass personally. He came across to me as intelligent, sincere, forthright, and honest. And I fully believe that he believes in his technology. And I believe that he wants to see its universal application across all table saws because of its potential to save fingers. But as pure as the as the motives are of those who support giving Dr. Gass a monopoly, I think it's a bad idea for many reasons. So many reasons that my official statement clocks in at over 5,000 words. I'm embarrassed. It's 5,000 words. But my esteemed colleague and friend, Commissioner Adler, you'll find it especially interesting to look at my application of the Piddle Doctrine for what constitutes the seven-pronged test for what constitutes a reasonable risk. And I'm sure I'll get a comment back to you and how I got it wrong in that particular
I very
case.
much look forward to it.
But let me highlight just 3 reasons why I believe this rule is bad public policy. First, there is no market failure. People can buy a saw with AIM technology if they want. I know it really annoys regulators and consumer groups, and of course Dr. Gass, who would like to sell more of his saws, that many consumers prefer saws without AIM technology. But it is a fact that consumers have choice. There is no market failure for the government to step in and address. And that word choice leads me to my second point. And this is my favorite quote from CPSC case law. An important predicate to Consumer Product Safety Commission action in promulgating a safety standard is that consumers be unaware of either the frequency, the severity, or ways of avoiding the risk, and if consumers had accurate information and still choose to incur the risk, then their judgment may well be reasonable. So again, as much as it might annoy some, consumers are aware and their judgment is reasonable. And finally, we should not stick our fingers in our ears and pretend not to hear the more than 1,000 Americans who took the time to reach out to us and tell us that this rule is unnecessary. Of the 1,600 comments we received thus far in the rulemaking process, fully 92% disapprove. There is a maxim articulated by President Obama's regulatory czar, Cass Sunstein, that I've tried to live by throughout my time at the Commission, and it particularly comes to mind today. Those who have the privilege of serving the American public should listen closely to those whom they are privileged to serve. Thank you.
Thank you to all of the commissioners and their offices for all the work that went into this package today, and thank you to staff for all of their work. And that, with that, this concludes the United States Consumer Product Safety Commission decisional hearing.